Hi, I'm Jennifer Hurless, President of PartnerSource, and this is your April 2021 Industry Update. In the next few minutes, I'm going to share the top 5 current developments in the Texas option industry. We're going to talk about the Texas legislative session, injury reporting, trends in benefit plan design, an anticipated Texas Supreme Court ruling, and finally, AcuteCare. First, the Texas legislature is in session. Now, in Texas, the legislature meets for 140 days every 2 years. And on January 12th, the 87th session began. Now, a lot of bills have been filed, but the one with the biggest potential impact to Texas option programs is Senate Bill 6 and its companion in the House, 3659. That bill provides COVID liability protections for businesses. Now, it does not provide blanket immunity, and it doesn't protect bad actors, but it does provide protection from litigation in businesses that have acted in good faith during the pandemic. Now, on April 8th, the bill was voted out of the Senate, which is a great sign this early in the session. There are other bills, COVID-related bills, that would provide a presumption of work-relatedness for individuals like nurses, first responders, and school districts. Those don't apply to us. Those apply only to employers and workers' comp. There are 3 other bills we're watching. House Bill 2654, relating to the determination of whether a person is intoxicated for purposes of the Texas Work Compact. There's House Bill 776 and the Senate Bill 305. These bills would mandate workers' comp for contractors and the subcontractors in the construction industry. And then finally, there's Senate Bill 209, which would impose restrictions on mandating arbitration. We don't know if any of those bills are going to make it out of committee, but we're watching those closely and we'll report back. Next, let's talk about injury reporting. Now, as many of you may know, the Dallas Regional Office of the Department of Labor decided to learn more about Texas option plans beginning about 5.5 years ago. They reviewed several plans and the administrative practices and expressed some concern about certain prompt injury reporting provisions as it relates to a claim for injury benefits. They're saying that the industry needs to move towards far more extended injury reporting timeframes. They specifically said that they don't like end of the work shift standard, or even 24-hour, 48-hour reporting timeframes are thought to be too short. And one step further, whatever timeframe is used, there should always be good cause analysis to determine if it was a good reason that the injury wasn't reported within that timeframe. Were they not trained? Did the manager drop the ball? Was the condition such that, it was reasonable not to report? Those types of questions should be asked to determine if there was good cause. Now, many of you may be thinking same-day reporting's been okay with OSHA for many years, and OSHA is part of the Department of Labor, so why the difference? And it's really a good question, one we've raised, especially in light of a 2011 Fifth Circuit case that appears on point, holding that a 24-hour reporting timeframe is reasonable under ERISA. But the point they're making is this, and it's a good one, that the right to access benefits under a benefit plan is and should be strong. If you're requiring action on the part of an employee, like to report an injury or get treatment within a certain period of time, then be fair about it and administer those provisions in the best interest of the employee, and apply good cause analysis to ensure its fairness. And remember to document the analysis in the notes. It has to be in the notes. And one last point, a successful program is one that takes care of injured workers. It's not one that denies a lot of claims. You shouldn't have a lot of denials for late reporting. And if you do, then it's a sign that it could be too tight, or you need to recommunicate the reporting expectation. Now, if you guys have an end of work shift or 24 or 48-hour injury reporting provision, your team leader will be discussing further with you if they haven't already. Next, the trends in Texas option benefit plan design. Now, Texas injury benefit plans have had a long history of innovation and continuous quality improvement. Some of the trends that we're seeing right now in option plan design are, first, removing unnecessary exclusions and limitations on coverage. Because option programs were roughly based off health plans in the 90s, many legacy option programs have some of those same limitations and sublimits on items like glasses or hearing aids or other random exclusions. Those limitations are rarely, if ever, used and probably shouldn't be part of good plan design. Those exclusions and limitations, They're not contrary to any regulatory guidance or case law, so it's not against the law, but we recommend you review them again because it may not make practical sense to have them, especially the ones that really aren't used, but may still foster a negative perception of your program when read. So the trend is to remove them and focus on good, reasonable medical management. Second, good cause. This relates to what we were talking about before in the feedback from the Department of Labor. We've used the term good cause for years, but many plans do not contain a definition of good cause. So in light of the Department of Labor's comments, and really in an effort to give those administering your plan good direction, adding a definition of good cause makes sense. Third, the claims regulations. Recall the ERISA disability claims regulations were changed in 2018. So your plan document should have been amended to address those rules then. But also remember, certain timeframes for filing a claim or an appeal were suspended during the pandemic. That suspension is now lifted, but it can be confusing to figure out the deadline to some of those old claims. Last month, we published an article about this in our March newsletter, and it's still on our website if you want to review that. Next up, we're watching very closely a case that the Texas Supreme Court has agreed to hear. This case, AROC, Inc. versus Boyd, involves an arbitration agreement between an employer and employee. In this case, the employer's training is provided through an electronic onboarding model. That model requires a unique user ID, a password, and an electronic signature, like many of you do. When the employee filed suit in state court, the employer filed a motion to compel, which was denied by the district court. But the only evidence or testimony that was provided to overcome this electronic agreement to arbitrate was the employee's own testimony that he simply didn't remember signing anything. And I think the dissent at the appellate court level said it best when he said, to suggest that an agreement is entitled to less recognition than any other because it was made electronically is contrary to controlling statutory law and could open every contract involving an electronic signature to costly nuisance value litigation and abuse. In this digital day and age, the enforceability of electronic agreements is of critical importance, and we are glad to see the Texas Supreme Court agree to hear this case. And we'll let you know when there's a ruling. And last but certainly not least is AcuteCare. Now, I hope this isn't the first time you've heard of AcuteCare, but just in case, AcuteCare was created by the trade association AROC, the Association for Responsible Alternatives to Workers' Comp. AROC is the industry trade association dedicated solely to protecting and promoting Texas injury plans. AROC now offers a no-cost, voluntary online designation to employers who have implemented a responsible program. The employer's program must satisfy 10 essential standards that are centered around legal compliance, fairness in how benefits are delivered, insurance protections, and professional claims administration. And it's essentially now a seal of approval for Texas injury benefit plans. The reason this was developed is because, according to the state, there are only two types of status. An employer is either a participant in workers' comp or they're not. That's it. There's nothing to distinguish responsible employers who replace workers' comp with a Texas injury benefit plan. But now, AcuteCare does this. So go to AcuteCare.org to learn more about the 10 standards. You'll see that a program who receives the designation can elect to put their name on a registry or not. Some employers are now referencing their AcuteCare status in the answers they file in litigation, using it as a way to bolster their reputation of their program. So visit AROC.org. They create and offer all kinds of helpful resources and are really representing your programs very well at both the federal and the state levels. If you haven't considered membership lately, I'd encourage you to take a look. This concludes our April 2021 industry update. Let us know if you find these video updates helpful. We're always looking for better ways to keep you informed of developments. And thank you for listening.